Last week, Commissioner Gallagher gave a speech that addressed broader concerns around the proxy process. It does seem that some of the Commission's rules around this process are outdated and in need of updating. No one wants to interfere with shareholders who have legitimate points from placing proposals to their fellow shareholders, but when we examine who we are making many of these submissions, it feels we have ventured from the original goals of the proxy process. Consistent with Commissioner Gallagher's speech, do you believe the Commission should revisit the resubmission thresholds and the holding period requirements?
I think that, and I know the proposal you're referencing, I think we call it in part the proxy plumbing proposal, and I think it has a number of issues in it, including the proxy advisory firm issue that we were discussing, and I think the issues are important to investors and important to companies, and by that I mean there's a range of issues. I mean not just the period of the period of time that should be applied in terms of purchases and so forth. I think that that whole set of issues is one that certainly has my attention. We obviously are trying to prioritize a lot of rulemakings there, but it contains a number of important issues, I think.
One of the issues we raised last year and was subject of debate before this committee and has some strong bipartisan support is legislation moving through Congress called the Email Privacy Act. Myself and Mr. Graves, along with a bipartisan group of congressmen and women, have co-sponsored this bill. I think most people on this subcommittee. And it responds to concerns that have been raised about the IRS, the SEC, and a number of our regulatory agencies that they are engaging in a practice of reading electronic correspondence of Americans without the due process of achieving a warrant or showing probable cause for reviewing those emails. The SEC has, I think, admitted to this practice, and I think it's come under some concern from a lot of Americans that the Federal Government would treat somehow electronic correspondence different than paper correspondence, the paper documents on our desk versus the file folders contained in our email accounts. All seem to probably have Fourth Amendment protections. This legislation is gaining a lot of steam in the House, and I guess my question for you is the SEC engaging in the practice of reading emails or other electronic correspondence of Americans without a warrant?
And I think we had this conversation last year, as I recall. And we certainly aren't reading emails live, which I think was part of our discussion last year. What the SEC has, we're not a criminal law enforcement agency, so we don't have the authority to get a criminal warrant. So that's one point. What we do have, and it's essentially there's a long line of established Supreme Court cases. We have the administrative subpoena power, as do most civil law enforcement agencies in one form or another, that can be used to ask a subscriber for their emails or ask a third party who may have documents, emails, including an ISP, for those emails. The practice that the SEC, so that's the authority the SEC has. A subpoena is very different than seizing something as you might when you need to have a warrant in a typical case. You basically, and the practice that the SEC has always followed with these is to, if they're subpoenaing the ISP, which I think is the area of interest, to give notice to the subscriber, who then has the opportunity to contest that subpoena if they so desire. I understand the privacy concerns. I think we talked about that last year as well. I think there are a number of different accommodations that can be made to actually heighten the privacy protections. What concerns me as a head of in part, large part, I suppose, law enforcement agency, is that we not put out of reach of lawful process. And again, it's a process that gives notice and opportunity to be heard. What is often, sometimes the only, but critical evidence of a serious securities fraud. I think you can balance the two. We certainly, happy to discuss exactly how to do that, and we use that authority, I think quite judiciously, but it's extremely important to law enforcement.
Which clearly your point is that you're not conducting law enforcement. You're conducting administrative review. You're conducting subpoena. I mean, if you're going to go forward with law enforcement, you're now looking at criminal sanctions on folks, and we believe just very strongly that that process needs to be one that protects the Fourth Amendment rights of every American. And there is the sense that we get from not only statements of the IRS that has blatantly said Americans do not have an expectation of privacy when it comes to their email. There's a sense that these subpoenas that are being issued, so we're not even talking about warrants, administrative subpoenas that are being issued, don't give due process, don't give notice, which you've described as protections for those, that these are being taken without notice to the subscriber. And that is one of the chief concerns that has driven the interest in fixing this. And so I'd love to see your comments or thoughts on, I think it's House Resolution 1852, to know what the SEC would amend or change about that to allow you to continue to carry out your functions while protecting the Fourth Amendment rights of our constituents who are frankly alarmed at just the intrusions of privacy that go on every day at this government, particularly when it comes to electronic correspondence that somehow perceived to be in the bureaucracy of this vast town that the Fourth Amendment doesn't apply there like it applies everywhere else. I know you have stated here you believe it does, and you're respecting that in your efforts, but I think we have some disagreements about how that's being administered, and I'd love to see your thoughts on how our bill could go forward to protect Americans with your input.
Happy to do that. And again, I would just say that I do think it's civil law enforcement, and I do call it law enforcement because I think that's what it is extraordinarily important. I also think the privacy interests that you're referencing are extraordinarily important too. And I think the way the SEC has done this, satisfy those requirements, or should. But again, I think there are any number of ways to do this, and we're very open to talking about other measures as well.
Thank you, Madam Chair. Thank you, Mr.